Good morning, everybody. Thank you for joining us today. Before I start, I have a few housekeeping items. If you have questions for us throughout the presentation, at the bottom of your screen, there's a Q&A link. You can type your questions there and we will either answer them right away or we will wait till the end, depending on what the question is. This presentation is being recorded and will be sent out to you in a link after the webinar. I am Andrea Thermos. I am the partner in charge of the Boulay Estate and Trust Department. I joined Boulay about 10 years ago and was promoted to partner in June of last year. I joined Boulay about 10 years ago and have about 20 years of experience in the estate and trust world, with my primary focus on tax compliance and planning as it relates to estate, trusts, and gifts. I serve on the MNCPA task force for the Estate and Personal Financial Planning Conference. And in my free time, I love to experiment with new recipes and entertain friends. I'm being joined today by Emily Blackburn. Emily joined Boulay in 2013. She's been the senior manager since 2020. Emily specializes in trust, estate, and gift tax compliance, comprehensive estate plans, and probate and estate administration, including asset management and trust funding. She draws from her education in both accounting and law to be able to provide a variety of services for her clients. In her free time, Emily enjoys spending time with friends and family, and of course, sampling every dessert that she can. She's got a major sweet tooth. In our estate and trust department, we assist clients in all stages of life, and through our holistic approach to estate and trust planning, we take into consideration the different objectives that you have throughout your life when it comes to retirement planning, charitable giving, and caring for loved ones. We strive to develop an estate plan tailored to your objectives, giving you confidence in the future of your estate. This morning, we are going to give you some insights and basics about revocable trusts, how they can be used as part of your estate plan, how to use them during your lifetime, and what happens to them when you pass. Take it away, Emily.
Thanks, Andrea. As Andrea mentioned, I'm Emily Blackburn. I'm going to start today just by kind of going over some of the basic structure and kind of the legal side and the drafting side of some of these types of trusts. And then Andrea is going to take over from there and kind of talk about some of the practical approaches. So when we're talking about trusts, typically there are two basic structures we can be referring to. There's a revocable trust, which is the topic of today's webinar, and then there's an irrevocable trust, which we will cover at a later webinar. The difference between the two, basically revocable means you have the ability to modify it. You can completely revoke it or cancel it. You can just change it as much as you wish during your life. And that's kind of the main purpose of a revocable trust, is the ability to change it. Irrevocable trust can't be changed except for under limited circumstances. In Minnesota, for example, we have things known as non-judicial settlement agreements, where beneficiaries of a trust, an irrevocable trust, can come together and say, hey, we need to modify this. It doesn't go against the material purpose of the trust. Everyone's in agreement. And we just all agree to change it. So you can sometimes modify them, or you can go to court and have a court order to modify, but typically irrevocable means you cannot change it. What determines whether or not a trust is revocable or irrevocable is strictly based on the trust agreement itself. So the provisions and the language contained within that trust document is really the guiding source of whether or not a trust is revocable. You can name a trust anything you want, but that's not necessarily determinative of whether or not that trust is revocable or irrevocable. So, sometimes we see things where there are trusts that are maybe named revocable and they've actually become irrevocable because someone passed away. So there can be confusion there. And one of the number one things we will always ask for when we get questions about a trust that is has already been put in place is, well, I need to see the trust document. I need to see what the provisions are in that trust to let me know how this trust is structured and how it functions, whether that's revocable or irrevocable. So again, those are kind of the two very basic types at their core. And the trust agreement is based on state law. So, if you are a resident of Minnesota, oftentimes you will have a Minnesota attorney help you draft a trust based on Minnesota's laws so that it is in line with, all of the statutes in our state, in line with the Minnesota estate tax kind of strategies. But you can have a trust, drafted in many, many states. All of them are based on state law, though. So that's something to keep in mind as well. So revocable trust, what do we use this for? What is its purpose? You've probably heard, revocable trusts referenced a lot in relation to estate planning, and that is really kind of their primary purpose. When we talk about revocable trusts, we talk about how they can be used instead of a primarily will-based estate plan. You can have a primarily revocable trust-based estate plan. Now, you will still have a will in place. However, that will is essentially going to pour over assets into this revocable trust, and we call it a pour over will. And so what happens is on your death, anything that was not titled in that revocable trust would then get poured over based on that smaller, shorter will, essentially. But those are kind of the two types of estate plans. There's a will-based plan and a revocable trust-based plan.
Hey, Emily, I have
Yes.
Someone is asking from your previous slide, if I establish my trust in Minnesota, but then move to another state, do I need to redo my trust for my new state?
So it depends. It's always the legal answer, right? I would recommend if you are moving to another state, establishing residency elsewhere, you have an attorney in that state review your current plan to make sure that it is still in line with the laws of that state and is still going to function the way that you want it to. Many states have laws in place that will recognize documents from other states as long as they were properly executed in the other states. However, laws vary greatly state to state. And so you want to make sure that you're getting with, a qualified attorney to really go over that document and make sure, does this still do what I intend for it to do? Is it going to have implications that I don't want or didn't foresee? So that's really important if you are going to change your residency. And that's with any estate plan, not just a revocable trust-based estate plan. So good question. When we are kind of approaching estate plans related to revocable trusts, a lot of people feel like, oh, it's a trust, I need that, that I've heard all these great things about it. That's definitely something I need as a part of my estate plan. And that may be true, but it also may not be true and may not work for your situation. So there are 4 kind of instances that we typically see in which a revocable trust-based plan would really make sense. First one is if you have real property owned in more than one state. So a home, a piece of land, a cabin, any of those types of real property. If you own that in more than one state, without those being titled in the name of a revocable trust, you would have to go through a probate in each of the states that those properties are located in. So, if you have the cabin in Wisconsin and your home is in Minnesota, for example, you're going to have to do your main probate in Minnesota if you don't have a revocable trust-based plan. And then you'll also have to do what's known as an ancillary probate in Wisconsin for that cabin. If, however, you have those titles, those deeds named in the revocable trust, that takes care of all of that. That probate process in each of those states is avoided. And so your trustee has the ability to execute the trust based on the provisions contained within it without having to go to court, and kind of saves you on some of those costs. Another reason that it can be helpful is if you need help managing assets. Some clients feel like as they're aging, or maybe they just aren't as comfortable handling finances, and they really want to be able to have someone help them out in managing their assets. You can name a co-trustee on your revocable trust that has the immediate authority to be able to help you administer all of these assets, kind of manage your affairs. It functions similar to like a power of attorney, for example, but they have a fiduciary duty under that trust document to basically carry out the provisions of the trust as well. So that's another way, that's another reason we say that a revocable trust-based plan can be helpful.
Emily, I have a question that builds on that. This person is asking, is it a good idea to put a primary residence into a revocable trust to protect it against the state in case the homeowner goes into a nursing home facility?
So because a revocable trust is revocable, I can't speak to specific aid programs or state-based programs. It's very fact-based, but oftentimes a revocable trust isn't going to really provide that protection. Because it's revocable, you have the ability to completely bring that asset back under your own control. And so in that sense, a revocable trust isn't typically the best sort of asset protection, but it is a very fact-based analysis. And so it would have to depend on what, type of aid and all of those things that we're looking at. So the third reason that we talk about using a revocable trust-based plan is if you are anticipating complications regarding your estate plan. That could be, disputes among beneficiaries, hard to identify or value assets, charitable beneficiaries that you don't necessarily want the court to, be involved in. If there are just complications overall, that having a will-based plan would possibly throw you into what's known as a formal probate. And that could be, more cumbersome. It can be more costly. It requires kind of more court guidance in terms of administering that estate. So if you foresee complications or, a will contest or something like that, a revocable trust can be helpful in the sense that, again, there's no process of going to court to, be able to administer this estate. You just have the trustee. They're able to immediately take action and administer that trust according to the terms of the trust agreement. The last reason we talk about is privacy. So the probate process is completely public. Once someone passes away and their will is filed with the probate court, the documents filed in that probate, it's all public and can be requested by anyone who wishes to see those documents. If privacy is a concern for you, or you just really don't want, someone being able to go down to the courthouse or request those documents, a revocable trust may be the right avenue for you. You can, name it something that isn't your own name if you should choose, and then that can provide you another layer of protection in terms of someone being able to find out, for example, what assets maybe you have. So that's another reason we typically say a revocable trust-based plan may be the right option. Oh, it looks like we have a few questions.
We do. Let me read it for you. First one, if real estate is owned in one state and an interest in a business partnership is in another, are the partnership interests included in the trust? Or should they be included in the trust, I guess is probably the question.
So can you read the question one more time? I'm trying to.
If real estate owned in one state, an interest in a business partnership in another,
got it.
Are the partnership interests included in the trust?
So, okay. So, you would want, if you have a trust, you would want any assets, including business interests, titled in the name of that trust so that it can all fall under that umbrella.
Right. And correct me if I'm wrong, but with partnerships that you have other, I mean, if you're in a state like Minnesota, you have different considerations of partnership ownership anyway,
Mm-hmm.
which you would work out with your estate planner.
Mm-hmm.
The next one, is there a benefit of putting real property into a trust to reduce liability risk due to only the assets in the trust being at risk in the case of litigation?
So again, I mean, a revocable trust itself doesn't normally provide a whole lot of a layer of protection in terms of being a separate entity from the individual because it's revocable. And so, you know, a revocable trust, you're still, as the grantor and trustee, presumably you're the trustee of your own trust, you still have control over all of those assets. And it's really just a way of passing these assets on and bypassing probate and, you know, doing it for some of these other reasons, but you still are essentially the owner of these things in terms of you're not a separate entity per se. You still use your social security number for everything that's reported within a revocable trust. You know, for tax purposes, it's still all your own income, expenses, things like that.
Right. Next, would it be beneficial to have a trust for a scenario of ownership of mineral rights in multiple states, but no real property ownership?
I think I have to think about this, but I think the mineral rights themselves would be intangible. And I think that that's not going to take away, for example, your income tax liability. Obviously, you're still going to file in multiple states. I don't know off the top of my head if those mineral rights to transfer, how that works, if they are in you know, the separate states. That's not something I know off the top of my head.
Whether they're probatable or not.
Right. If you have to, yes, exactly. If you have to go through the probate process in that particular state, that's something I'm not sure, but we could probably find out.
Okay. Next, if my cabin, for example, is in my will, but I forget to title the cabin into my revocable trust, will it end up in my trust as a result of my pour over will, or will it have to go through probate?
So it would have to still go through probate. The purpose of the pour over will is basically to catch any of those assets that are unfortunately missed in titling in the name of the revocable trust. Any probate assets that are missed, I should say. Things that have a beneficiary designation like life insurance, 401k, things like that. If you have a named beneficiary, we don't worry about those. Those are going to pass, you know, according to that designation. But the pour over will catch any of those assets that you forget, but you have to go through probate in order to get them into that revocable trust, unfortunately. Yep.
If I keep asking you questions, you'll do my presentation.
Yeah, I
know. There's two more.
Okay.
Does one need to complete a transfer of deed for a home if the home is not specifically named in the revocable trust?
Yes. Yeah. Typically, it's a quitclaim deed from the individual to the trustee of the revocable trust. Yep.
And the attorney that you're working with to create your revocable trust plan and your estate plan should be able to assist you with that process. Or if it's in another state, they can either help you with that process depending on how easy the deed transfer is in that other state. And then the last question, which spouse's trust should the major assets be in? Can the survivor change the revocable trust?
So the survivor can change their own revocable trust. They cannot change the revocable trust of the decedent spouse. It becomes irrevocable upon death. Which trust it should be in, or if it should be divided between trusts, that's really an analysis of your assets, total value, estate tax implications for federal and Minnesota, if Minnesota is your resident state. So that's really a larger question and is very, very fact specific based on your individual estate plan, your goals. That's something that you would have to sit down with your attorney to kind of figure out what the most beneficial structure would be.
There's a couple more questions, but I'm going to move ahead with my part of the presentation.
Perfect.
Some of them might get answered.
Yep.
And we'll address the rest of the questions either during my presentation or
At the end.
at the end.
Awesome. I will move ahead for you.
Thank you. Thanks, Emily.
Yep.
So I'm going to cover the revocable trust, what occurs during administration during your lifetime, what the control of asset looks like, and as is listed here, your trustee, grantor things, and then why you title things the way you do. So if you created the trust, you're the grantor. You may be called a settler. You may be called a multitude of other things, but you are the person who established the trust. With that comes the right of naming a trustee or becoming the trustee. I would say in most instances, the grantor of a revocable trust is also the trustee of that trust. You retain, so as Emily mentioned, you retain the right to sell, give away, invest, and otherwise manage the property just as you would before if the assets weren't in a trust. You control the terms. You can change the beneficiaries. You can change the terms of the trust. You can add assets. You can take assets out. You can sell them. They're all reported to you under your Social Security number and reported on your individual income tax return when there's earnings or sales of assets. Properly funded revocable trust can streamline the management of your estate. It could potentially keep your family from having to go through the probate process. As Emily mentioned, that you have, Minnesota has informal probate and formal probate, and depending on the complexity of the estate and the makeup of the estate and the agreement of the beneficiaries, informal probate is often the way that we direct our clients, but sometimes you end up going through a formal probate because of disputes. So when I mention funding, I'm referring to the process of retitling your assets into the name of your trust. So asset retitling. They are owned under the name of the trust, and they're owned under the name of the trustee in their fiduciary capacity. So if I established a trust, it would be the Andrea Thermos trustee as trustee of the Andrea Thermos Revocable Trust. Sorry. So you might ask, why does the titling of the assets matter? The assets, as I said, are owned under the name of the trust, and it's important so that it is clear that your assets are held in your trust. And what should the titling look like? Again, as I mentioned, it would be the Andrea Thermos. It would be Andrea Thermos as the trustee of the Andrea Thermos Revocable Trust. So what happens if an asset is missed? So that was, I think, multiple questions or several questions asked that. What happens if an asset is missed when my funding occurs? So depending upon the asset or the assets missed, your estate could become subject to probate in your state of residence or in another state if you have real estate in that other state. So setting up the revocable trust can seem like a lengthy process. You have to retitle all of your major assets. You have to go through the process of establishing the fact that you have a revocable trust. So when you're working with a broker like Wells Fargo or US Bank, and they're managing your assets for you, when you retitle your assets from yourself into your revocable trust, they want proof that that revocable trust exists. They also want to title it correctly as described in the examples. So the process can be lengthy, but the beauty of you doing the process is you know what you own, where your assets are held, where the account numbers are, who to contact. It's, I think, to the benefit of your beneficiaries and your future trustee that you manage things that way. And there are assets to be mindful of. As Emily mentioned, assets such as life insurance and retirement accounts have named beneficiaries, and those assets go to those named beneficiaries by design. They don't become a probatable asset unless the named beneficiary has passed away and it's now an asset of your estate, and there's no secondary beneficiaries. So in addition to establishing a trust, a revocable trust, sometimes it's a good time to also review your beneficiary designations and make sure they're current and up to date. I had an instance where a client passed and he had an old IRA that at the time of his first divorce, the IRA was worth about $10,000, and when he passed away, it was worth about $500,000. And they ended up going through a litigation process because that beneficiary designation never got switched from the wife whom he divorced. So thinking through things like that, in addition to working through your revocable trust planning, also looking at your beneficiary designations. Another set of assets that you want to consider when you're thinking of a revocable trust and naming and asset titling. Do you have assets that may not have clear title, or in which there may be significant steps to transfer the asset into your estate or to a beneficiary? So clear title, do you own something with another family member who's not your spouse? Something that just is just not, it's not clear that you are the sole owner, or you own it with right of survivorship or joint tenancy. So sometimes that's a consideration. And then the other item that I said, there may be significant steps. When you have holdings of securities that you hold directly with the company, like you own Disney stock directly with Disney, not through a brokerage account, the steps that you have to take become more and more cumbersome as time goes on. I know that you have to if you're going to do the transfer yourself and not transfer it through a broker, you have to get what's called a medallion signature, and that just takes additional time. So I think that's it on titling. The next slide is estate administration during, at death. For that, the biggest thing to remember, the trust that is revocable while you're alive becomes irrevocable upon your death. As Emily mentioned, no matter what the title is of that trust, it is still irrevocable upon your death. The reason for the title remaining the Andrea Thermos Revocable Trust is for clear direction of where those assets go upon administration of the trust. That revocable trust is what we call an estate administration trust. And with proper planning and sufficient steps ahead of time, you can make your life easier and your beneficiary's life easier and your future trustee's life easier if you move those assets while you're alive and you know where to find all the information. I have lots of examples, but I won't go into all of them. I would rather answer the questions that we have.
Yeah, I was going to say, we have a few questions. So one of them is, why wouldn't I put all major assets into the revocable trust to avoid probate?
You would put all your major assets into a revocable trust. I can't think of a reason why you wouldn't, unless you have some other planning technique that you're using. People who are under a taxable estate sometimes name beneficiary designations. So if you have one child, you may have everything set up to transfer on death. And then you wouldn't need a trust if you have everything designated transfer on death, but that can become complicated. when it's not titled correctly or the wrong beneficiary is named.
Yeah, and just to piggyback off of that, I think it's really a conversation about whether probate avoidance is important or not. There are many estates, probate in Minnesota, it can be pretty quick, pretty easy, and not as cumbersome as it is in other states. So probate avoidance may not be something that is a concern. If it is, certainly you'd want to title within a revocable trust, but it's not necessarily always the need for someone's estate. If a residence is transferred into a trust, does the individual lose the homestead credit on real estate taxes?
No, you're still, a revocable trust is still owned by you. It's a trust in which you can put assets into and take assets out. And for tax purposes, whether it's real estate tax or income tax, it's basically an ignored entity, and you're reporting it as if you were the owner directly.
Okay, next one. I know we're going over time here, but we're happy to keep answering questions. So
I'm going to dismiss the ones we've answered. There we go.
Okay. Let's see. Should you set up assets in separate trusts or all assets in a marital trust? Would they flow from one to the other in the event of a death?
Do you want to answer that, or do you want me to answer that?
I can, that's fine. So typically, and this actually kind of answers
The next
another
one.
question that I think was that it kind of also answers. So in Minnesota, we're not a community property state, so we often have separate trusts for husband and wife, for example, because it's easier, honestly, to track asset ownership. In states where they have community property laws, there is something known as a joint revocable trust, and that's often a strategy used there. You certainly can do that, but it's not as common in Minnesota. And how assets flow really is just dependent on what your trust document says. You can have them go anywhere. Marital trust structure is something that's often used when the first spouse dies to provide for that second spouse, but be able to take advantage of the marital tax deduction. So there are definitely structures in place, but you want to note that you can also take advantage of all those trust structures within a will-based plan too. That's not something that is only within a revocable trust. You can take advantage of all of those same tax strategies under a will-based plan too.
I can read the next one.
Okay, perfect.
Because I think it's more legal.
Okay.
If a husband and wife are both trustees, owners of a single trust, so a joint trust, does it become irrevocable if one of the spouses dies?
So again, this is going to go back to the trust agreement, the trust document, but oftentimes what happens is there will be a survivor portion of that trust. And so the assets that are a part of that survivor portion will still be revocable, but the decedent's portion is going to be irrevocable, just like it would if there were separate trusts.
Is it accurate that a revocable trust is also not revocable upon being incapacitated or incompetent, like dementia?
So this depends on if there are, other trustees or what their powers are, or if you've named, if they have a durable power of attorney in place, that can still allow someone to make decisions for you, even if, incapacitated. Once you pass away, obviously, then they cannot, but there are still ways for certain actions to take place if someone's incapacitated.
The next question, I think we answered already. It has to do with ownership on a joint trust and what happens if one of you dies. This question, what about valuable personal property if the sum is over the Minnesota probate amount?
So, it depends on what the amount is. Right now it's, I think, $75,000. If you have an estate that's over that, you're not able to use the affidavit of collection, which is kind of just a document saying, hey, this person's probate estate is under this value, and without having to go through the full-on probate process, we have the authority to handle these probate assets. But if it's over that, or if there's any real property
If
involved,
there's real property,
yep, if there's any real property involved, then you have to go through that.
no matter what the value is. If it's a $10,000 wetland, you still have to go through the process.
Yep.
And then lastly, if a revocable trust is not effective for medical assistance lien avoidance, what is?
This is not my area of specialty, but there are, supplemental needs trusts, special needs trusts, things like that, can be drafted for that specific purpose to help provide support for people without negating their ability to get public assistance.
And there are attorneys who specialize in both elder law and special needs law.
Exactly.
So if you're thinking for Medicare purposes, I would seek out an elder law, an attorney that specializes in elder law, because that's a really important piece of the planning process. That's all the questions we have. I'm so thrilled that you all joined us today, and look forward to serving you or helping you out with your future estate planning needs. This is contact information for us, and the previous screen had Emily and I. Again, as I mentioned at the beginning, this webinar was recorded, and you will get a link to that for future viewing on YouTube. Thank you today. Thanks, Emily.
Thank you.